Watch this video if you're interested in learning the strategy that Young Thug's attorney, Brian Steele, is using to help get him out of this RICO case. Yesterday, court started again after nearly a month break, and there's a new judge on the case, Judge Paige Whitaker. During yesterday's hearing, Judge Whitaker made it clear that she did not want to handle any substantive decisions.
I'm just going to make sure, Mr. Steele, that I've got all of the ones that you believe to be pending. So I saw in your email a July 8th and a July 9th motion to recuse both Judge Glanville and Judge Krause, which I'm obviously, we're not going to do anything substantive here today. I'm just going to make sure I know what y'all believe to be pending.
Even still, Brian Steele decided he needed to take advantage of this opportunity to try to plant the seed of what he hopes grows into probably a mistrial. Take a look.
And are you going to file it? You're just giving me a preview, or?
I could file it.
Okay.
I'll do whatever the Honorable Court desires. So I just want to bring to the court's attention, to be, fair to the court. May I approach, Your Honor?
Yes. And it may be easiest to just hand it to Ms. Pursfield. And y'all, it's on my mind right now. Before we all leave here today, I want to make sure that my staff has cell numbers for everybody. Okay. All right.
So I've handed this Honorable Court's co-worker and the state two cases, PROPST versus Morgan, MORGAN, and it's 288 Georgia, 862, 708 Southeast 2D, 211. And if you look at page 2 of the copy of the case that I've handed to this Honorable Court and the state, on the left-hand side, on the bottom last paragraph, our highest court explained that another line of appellate decisions holds that if a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and have no effect. And the reason I raise that is, Your Honor may be aware but may not be, the Honorable Douglas Weinstein filed an initial motion to recuse Judge Glanville. He did that on June 12th of 2024 in the afternoon hours. Judge Glanville initially he stopped proceedings and he denied that motion without referring it to another judge, and he made some findings of why he's denying it. On behalf of Mr. Williams, the Honorable, yes.
Was there a written order?
He did file a written order.
June the 14th.
Okay.
2 days later.
All right.
And that was the Honorable Douglas Weinstein.
Okay.
The Honorable Keith Adams and I, on behalf of Mr. Williams, then filed a motion to recuse, but we didn't file ours until June 17th. It's Monday, June 17th.
Okay.
But the way I understand the case law is that once Attorney Weinstein filed that motion, which the Honorable Judge Krause eventually granted. Judge Krause, in a written order dated, I'm going to tell you, July 15, 2024, granted Mr. Williams as well as Mr. Kendrick. Mr. Weinstein represents Mr. Kendrick, both of the motions. So the way I understand the case law is everything that happened after the filing by Mr. Weinstein on June 12, 2024 is invalid.
Okay. So if you would do me a favor and put that in writing and file it as a motion, and then I will add that to our pending list.
Yes.
And I appreciate you letting me know, I don't want to get into substantive argument about anything today because we don't have the parties themselves here. This is basically just a sort of status. So if you will file something to that effect, then I'll have that added to the list. But I appreciate that.
I'll file
Thank you.
today. Can I add one other thing just for your knowledge? But
Sure.
if it's something that's more than a status, then I will withdraw it.
Yeah, and I mean, you can tell me, but I'm, not going to consider it. We're not going to argue it. But yes, absolutely. Go ahead.
Understood. I just want you to know that there was a witness testifying. That's why I thought it's important, which will potentially, if you determine it, require the jury to have their notes, if you require it taken away and then wiping out what they heard. I just want you to be aware of that.
Okay, I'm not sure if I follow what you're saying now.
So there was a witness testifying. His name is Mr. Copeland.
Yeah.
After Judge Glanville denied that motion, the
Okay.
jury heard from a witness on the afternoon of June 12th, June 13th, June 14th, and then June 17th. So I just want you to be aware.
All right, I understand what you're saying now. All right, thank you.
Other than that, those are the
All right.
motions.
Great. Okay. For Mr.
As you can see from Steele's motion that he filed yesterday, Brian Steele is still not giving up on the ex parte meeting as one of his best opportunities to help get Thug and probably the other defendants out of jail. Steele filed this motion. We're going to read it here so that you have a full understanding of exactly how he's using it in his strategy. The key concept is that the ex parte meeting that Glanville held with the prosecution and Woody prejudiced not only Young Thug, but the whole trial, all of the defendants in the trial. But there's a problem. The previous judge who ruled on Glanville's recusal, Judge Cross, actually said that the ex parte meeting was not a problem. So she removed Glanville, but not due to the ex parte meeting, but instead due to his reaction after the ex parte meeting became public. So this is what Judge Cross said. It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken place in court, nothing about the fact of the meeting or the substance discussed was inherently improper. So there you have it. Judge Cross is saying the ex parte meeting was fine. Yeah, it would have been better to do it in court, but in all, it was okay. This has actually damaged Brian Steele's strategy because he still wants to use the ex parte meeting to get a mistrial. But how can he do that if Judge Cross just ruled the ex parte meeting as fine, as okay, as good to go? That's where Steele's motion comes into play, his new motion with the new judge. He's filing a new motion asking the new judge to essentially overturn or rule against or have another finding other than the one that Cross found. You see that here Steele writes, the Honorable Judge Cross made two findings that are respectfully erroneous in her order granting the recusal of Judge Glanville. 1. Judge Cross wrote, divorced from its hyperbole, Mr. Williams' motion and supplement also seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. Here, Steele is taking exception to Judge Cross's having said that his motion contained hyperbole. But the important part is part 2. It is worth noting that the Honorable Judge Cross agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting, and Steele says about that, this finding is wholly against the law. At this improper ex parte meeting, Mr. Williams and his counsel had a right to be present for several reasons, including but not limited to 1, the fact that Mr. Copeland provided statements not only bearing on the substance of his testimony, but also on his credibility. 2, there was enormous amounts of Brady evidence shared at this improper ex parte meeting that lawyers Love and Hilton and Judge Glanville all attempted to keep secret from undersigned counsel. And 3, there was no lawful reason for this ex parte get together. So basically, This is the crux of Steele's entire strategy at this moment. He is looking to get this ex parte meeting reintroduced as a potential problem, hopefully get a beneficial ruling on it. And then what happens after that? If he can reintroduce the ex parte meeting as an issue, get a favorable ruling for Young Thug and the other defendants, then what he can do is from that point exclude all of Woody's testimony, rewind the trial, and perhaps even prove that this trial has been fundamentally, inherently, to its core, damaged irreparably, and hopefully get a mistrial. So what Steele is really trying to do is undermine the entire trial based on this ex parte meeting, get Woody's testimony thrown out, throw the trial into chaos, basically, throw the trial into chaos such that it can't be repaired, such that this has to be declared a mistrial. And so that this entire thing either has to start over from day one, or even better, is dismissed with prejudice and can't be brought up again. So what do you think? Do you think Steele's strategy is going to work? Let us know in the comments. Also, as always, don't forget to like, subscribe, and share this video out. Appreciate it. We'll see you back next time.